time. This is great. I'm Mike Cioffi with the Friends of Liberty. We're very, very proud that we organized this training session on FOIA. And more than that, we're very honored to have with us Maria J.K. Everett, who is the Executive Director of the Virginia Freedom of Information Advisory Council, which is a legislative agency created in 2000, in July of 2000. And since its inception, the FOIA Council has rendered more than 24,000 informal and formal opinions on the application and interpretation of the Freedom of Information Act, and has conducted over 900 training sessions of FOIA. So we really are blessed to have Maria with us. Maria is also a senior attorney with the Division of Legislative Services and serves as counsel to the House Committee on General Laws. And with that, we're just a little bit of housekeeping. Our initial intent was to have Maria give us her wealth of knowledge from 7 to around 8:30, and then questions and answers afterwards. But Maria said, if something comes up while she's talking, please don't be bashful and ask questions during her presentation. So again, with that, Maria, thank you.
Mike. Good evening. Thank you all for being here. It was a great drive. You know, it's always nice to get away. So what I would like to do is, I say this to everybody I teach, which is, feel free to ask any question about the Freedom of Information Act. Secure in the knowledge there is no such thing as a stupid FOIA question. Alan and I answer about 1,800 emails and phone calls a year. We have yet to hang up the phone and go, oh my word, what an idiot. Right? So I'm throwing the gauntlet down to you good citizens to be the first ones. I throw the gauntlet to everyone. Nobody has wronged the stupid FOIA question yet. So, yes sir?
I'll start, Chandra.
Okay.
Is the Freedom of Information Act federal, state, or both?
It is, well, it's both. There is a federal Freedom of Information Act, and it applies to federal agencies. So we don't care about it necessarily in Virginia, as Virginia government. There's a Virginia Freedom of Information Act. Most every state has a Freedom of Information Act. Some call it Open Records Law, Open Meetings Law. In Virginia, the law that governs our interaction with government is the Virginia Freedom of Information Act. So the Freedom of Information Act, FOIA, right, that's what we've turned it into. We've turned it into a verb. Have you been FOIA'd? It's an adverb. Is it FOIA-able? And there's actually a song, but I'm not going to sing it for you tonight, about that just kind of goes to, and it's from like the late 70s, Johnny Guitar Watson. Y'all look it up on YouTube. And the words are, when you look, you will discover that it's a real mother FOIA. Oh, it's a real mother FOIA. I don't think that's really what he meant, but it's kind of my theme song. So Johnny Guitar Watson, and the extent that FOIA, the Maria codicil is, to the extent FOIA becomes a mother, is a lot of times it's sort of negative interaction between government and its citizens. You know, and we turn it into that. On its own, it is not. So it's a state law. It's not Maria's wild idea. It's not a guideline. It is not a regulation. It is the state law. And we cover two things under FOIA. Open meetings law, which the guarantee under this law is ready access to the records in the possession of government. On the meeting side of FOIA, I understand the Board of Supervisors meets at this holy table. On the meeting side of FOIA, it is the guarantee, the policy is to afford every citizen every opportunity to witness the operation of government. So it's the idea on the meeting side of this law that the deliberative process is just as important as the decisions that the Board of Supervisors or the school board or any deliberative body are making. So you have an opportunity as citizens to witness the operation of government. But under FOIA, it's eyes and ears. It has no requirement for public comment, but most governmental units, local governing bodies, have a public comment period. So that's the difference, and we can slide on meetings law, we can slide on records law. So we're going to start, because as I understand it, this is majority citizens. And again, my husband told me, he said, well, that's really odd. You're going to go talk to a bunch of citizens about FOIA. I'm like, well, that's kind of my job, honey. And then, but he was like, but you always talk to the government side. And it's true. But so I appreciate, because I strongly feel that there is a responsibility of citizenship. And the fact that you're here is, proof to that. So what I have found, and let me tell you about the FOIA Council. I'm the government, okay? So of course I am here to help. And I mean that sincerely. When I do my general laws committee work, the Freedom of Information Act comes to my committee. So I'm sort of in a catbird seat. I write the law, I staff the committee it goes to, and then I opine on that same law. So my easy way out is on FOIA bills specifically. If I'm not really understanding, what I tell people is, I don't know what this means now. And later I'm going to have to opine on it. So we got to figure out some clearer language about that. So what I found, the FOIA Council, we were studying the Freedom of Information Act from 1998 to 2000. And what happened during the course of that study, it was like, we had email and we had electronic records, and it was like, oh no, is the law cover that? Well, the press did what they call a FOIA audit. They sent reporters to all levels of government, because this law, the Virginia Freedom of Information Act, applies to state, local, and everybody, public service authorities. It can apply to area agencies on aging if they're principally supported by public funds. So this law covers a multitude of levels of government. So it can't get down into the weeds. It's got these policy ideas. And so what happened is, when the press audit occurred, they went to sheriff's offices, everybody, all levels of government, and asked for records that should have been released, no questions asked. Virginia's compliance rate in 1999 was 16%. I am sort of an optimist. I was like, woohoo, double digits, heading to 20. But the point was made that those of us in government have all obligation under this law, and we don't know anything about it. I went to law school. Nobody said FOIA to me. The bar exam didn't have anything about FOIA on it. And, and the idea is, let's create something at the state level, or in the legislative branch, not that that really matters, that can answer people's questions, whether they be citizens, media, or the government. This law is supposed to be interactive, communicative. We're all citizens. We're all on the same team. So let's not get into adversarial posturing, because that's the law comes at it as people will talk and decide what it is they want, and it will be provided to them. And so the FOIA Council was created, so as state agencies go, we're 17 years old, to issue opinions. And we do that through formal written opinions that appear on our website, and then, like I said, the 1,800 emails and phone calls. We produce educational materials, and you saw that when you came, and take a look at our website. It's got tons of stuff. And also we do training. So I'm doing simultaneously all of my statutory duties at one time. Okay. Now what I found in 15 or 17 years of FOIA work, I live in FOIA land, okay? You all visit. Okay, government visits FOIA land. I live there, Alan lives there. So we think about this stuff all the time, which tells you how interesting a person I am. Okay? It is, it's sad. I like this law. I also like public procurement. So, see what I'm revealing way too much about what a loser I really truly am. But what I have found is that all of us citizens, and the constituency of FOIA is citizens, media, and government. That's it. Now, the way the law is structured, citizens and media can be pesky at times. That's their right. But they can never violate the law. That is distinctly the privilege of the government. Okay? But like I said, I went to law school and nobody talked FOIA. So for government people, and I'm not offering excuses, I'm just saying, think about this. Somebody in here decides, I'm going to work for the county. You know FOIA? If you sit in your chair long enough in your government office, will it somehow come up through your seat and into your brain? So you see it's an ignorance problem. All of us have, all of us, everybody, media, citizens, government. We all have perceptions of what we think this law means. So tonight is what this law actually does, and to dispel myths about FOIA. Okay? So myth number 1. FOIA is about getting records from government. It is not about answering questions. Okay? Because the Freedom of Information Act, the whole purpose of it and the record side, like I said, ready access to records is the possession of government. But the idea is it balances the right of access against the need of government to function. It's a balancing test because the government, except for me, most everybody else in government has been hired to do something else. And FOIA is sort of sidelined, those other duties as assigned, And like I said, so it's about getting records. And so the balance is, FOIA is about being responsive to citizens. FOIA requests and public records, and we're going to talk about what the heck is a public record. It's a semi-permeable membrane. Things come into the government and most things come right back out. That's the point. That's the point. But it's about getting records, not answering questions. Because in the balance, if it was just people in government answer people's questions by and large, but it is not a FOIA request. That's what I want. My point is, a FOIA request is I want to look at your record, I want to receive copies of your record. It is not tell me why you did this. That is not a FOIA request. And as I ask people in government, are you in government for the money? And most people, it takes about 2 seconds, and then you hear smirking, And so we all, whether you believe it or not, have something in common as public servants, that we have this public service orientation. We want to help people. That's why we got in government. It's not because we're losers and we can't make it on the outside. Okay? We chose this profession. But being a public servant is not a slave. We're not whipping boys and girls. So again, adversarial things, and that's that handout about how you structure your FOIA request. And we all know, if you lead with, I want these records, I pay your salary. I mean, what do you think is going to happen? Right? You got, honey versus vinegar. Again, I am a realist. The one bite rule. Once you've been bitten, okay. So it's about getting records from government. The right that you have as a citizen is to look at records or to receive copies of them. Your choice. Third, FOIA is not free. Okay? Most states don't allow for charging for FOIA requests because the idea is you get paid, I get paid my salary whether I respond to a FOIA request or not. But Virginia, as we all know, is the pay-as-you-go state, right? We have to have a balanced budget. So again, in this balance between the right of access, which is a little heavier than the need of government to function, and we'll talk about how that comes into play, is that government can charge you. But the statute says what they can charge you, and one of the handouts that I left out there, and I will show it to you now, has all of our contact information in the back. Yes, it's called Taking the Shock Out of Charges. Ha ha ha. Maria, in an inner tube floating down the Rappahannock River, came up with this. See, I'm a loser. There you go. But it will explain to you. So the statute, charging under FOIA, they don't have to charge you, but they can. But there's limits. It's cost recovery, not revenue generation. Okay? Third point, or fourth. There's no such thing as a formal FOIA request or an informal FOIA request. Because FOIA requests do not have to be in writing. FOIA requests can come on the phone. You can go to the office and make a FOIA request. Now think about that if you were the government. Doesn't have to be in writing, and the magic word FOIA doesn't have to be mentioned. So it's a little dicey when you think about it. Again, somebody new, you've come from the private sector, you sit down and somebody asks for something, it's like, what? Now, if we get something, we have a FOIA request form because putting it in writing is not required, but it is recourse. It tells it's clear communication, we want this. Because on the government side, when they receive a FOIA request that's in writing, whether it's an email and mentions FOIA, it's like, dang, it's a FOIA request, and lights go off and everybody knows what it is. But again, the idea is it would be nicer if they could say FOIA, but it's not required because on the other side, on the citizen side, we want you having the cite statute. No. Because what if you said under the open government law? Does that be like, wrong? No. So that's the whole idea of the semi-permeable membrane, okay? So when you ask, I want to look at, I want to receive copies, it's still a FOIA request. Now, the final point, which is a very nuanced point. The Freedom of Information Act is what we call a mandatory disclosure statute, which means every record in the possession of government is presumed open and must be given out. Mandatory disclosure unless state or federal law says it doesn't have to be. But FOIA doesn't prevent release. FOIA just says in this balance the need of government to function. Think about it. Who in here has a library card? Okay, what does the government have? Your name, your address. Now, somebody under FOIA went to the local library and said, I want the names, I want the list of everybody who has a library card in Rappahannock County. Your name goes out with your address. Now, what FOIA would prevent or say is your name connected with the materials that you're checking out or looking at cannot be released, are not subject to mandatory disclosure. Okay, so mandatory disclosure is a pretty easy, I use a baseball analogy. All you have to be as a requester is reasonably specific, which is kind of a funny term, reasonably specific. So that was our first opinion. Do we know what you're looking for? Do we have enough information to know? And if we're not clear, to say, hey, you want this kind of stuff? Because government keeps records in different ways. There's no law that says how records. Like, let's talk about a building code violation. Do they keep the records by chronology, by the date it occurred, or do they keep it by address? How would you guys know that? So that conversation, I'm looking for building code violations at 8110 Ridge Road. Well, we don't keep them that way. We don't keep them by address. So you see sort of the dynamics that FOIA is like, it's a little mushy sometimes. But mandatory, just you have to be reasonably specific in identifying the records you want. Then all of those records, whatever form they're in, are on deck. And to the extent state or federal law allows you to take some portion, the government to redact some portion of it or even take the whole record off, but they have to cite their authority for doing it in writing. If there is none and they call us and we're like, no, that has to be released, then it goes to the field of play. That's what mandatory disclosure means. So, what is a public record? Kind of an important thing to know. What we define it as anything, regardless of physical form or characteristic, however it's stored. It can be a videotape on a bus. It can be body-worn camera footage. It can be dashboard camera footage. It could be CDs. More and more government is having big honking databases. It can be databases, it's electronic records, it's anything, whatever form. I was in Winchester a couple of weeks ago, and they had these wonderful written history of the city on the walls. All of them public records. So it could be something hanging on the wall, okay? Anything that, so we don't care what form it's in, it could be paper, that the government owns, that we've prepared, are merely in our possession as it relates to the transaction of the public business of that particular government, okay? So for me, I'm the general laws attorney. I don't really get FOIA requests in that because legislation is open. But on the FOIA side, yeah, we have been FOIA'd. And the idea was, well, was it a reasonably specific request? Sure it was. And I had to run it through well, is it exempt from mandatory disclosure? Yes or no? But FOIA also gives government discretion to release things that are exempt from mandatory disclosure. So under FOIA, you don't have to give out certain records, but you can if you want to. The government can if they want to, unless it's prohibited somewhere else. For example, social service records about child protective services, adult protective services, they are prohibited under Virginia law to be released. Juvenile justice records. Any juvie perpetrator is prohibited from being released. We have a Protection of Social Security Numbers Act, which says the first 5 digits in anybody's Social Security number in any public record must be taken out. They cannot. But when this law was written in 1968, there were 5 exemptions from mandatory disclosure. Personnel records, health records, criminal investigative records, and tax records. I can't remember all 5. Now there are 165 exemptions from mandatory disclosure. Now, some of you are like, what is this, Swiss cheese? This kind of law? But the way Virginia's approach to writing FOIA exemptions is we have very specific, narrowly tailored exemptions that are for one agency, and another agency may do something like it, but if they're not named there, they do not have that exemption. We don't have these wild general exemptions. Like, let me give you an example. New York and Connecticut, by the way, have an exemption that if the request would be an unwarranted invasion of personal privacy, it's exempt. Well, that sounds pretty good at first, doesn't it? But what the heck is that? An unwarranted invasion of personal privacy. So Virginia never goes to these glaring kind of things. They say, the most general is personnel records, because we know what that is, HR. But they're very specific. So FOIA recognizes in this balance between access and the need of government to function that there are times the government needs to play it close to the vest. And it's always in the public interest. Criminal investigative records are exempt from mandatory disclosure. Why is that? We don't have to give the bad guys our investigative notes because we want to aid in the apprehension. We protect it in the name of public safety. If there was something that happened at this courthouse, that there's tactical plans that the sheriff would do in the event of some hazard, we certainly don't have to release those to the public. First, they're going to show up, and then they're going to be armed with this. You see, some of it just makes complete and utter sense. When the government is negotiating a contract to build a building, or with another government body to sell water or whatever the issue is, while we're in the throes of the negotiation, we don't have to release records because it would damage the public's position. Another example, real estate. Whether we're talking about buying or selling real estate, the Board of Supervisors, or we're just talking well, it's really mostly buying or selling. So I'll use myself. There's a vacant lot next to my house in Richmond. Let's just pretend I own it. If I knew that Henrico County, where I live, wanted to buy that parcel of land that I owned, who thinks the price of that land would go up? Right? And what would be, excuse me, the story in the newspapers? You bunch of blabbermouths in the county. You told people what you wanted that parcel for, and you had to pay more of the public's money because you didn't hold it kind of close to the vest. You didn't protect the public's position. So you see, FOIA has, these 165 are very specific exemptions, like privacy-based, like what I was talking about, library cards. Your name by itself as a list of library recipients, people who have library cards. The law changed, so if you're under 18, that's not required to be released. But if it attaches to what you're checking out, then no, it is not subject to mandatory disclosure. But like I said, the law says the following records are excluded from mandatory disclosure, but may be released in the discretion of the custodian unless it's prohibited somewhere else. So how would you feel if somebody called to the public library and said, we want a list of every citizen who has a library card? Somehow, when it's our own personal information, we're like, oh, they shouldn't release that. Well, the law, that is subject to mandatory disclosure. So we see it differently as citizens in certain ways. We don't want our stuff out, but we want everybody else's stuff out. Okay, so that's the first. So those are kind of the myths. So back to what the heck a public record is. Do we own it on the government side? Do we prepare it, or it's merely in our possession? Which means, I think of it this way. In the government, we have a line from our side to infinity. And anytime anything crosses that line in the transaction of the public business, the specific public business of the Rappahannock County Board of Supervisors, or the school board, or the FOIA council, it is a public record by definition. But in FOIA land where I live, the right question is not whether it's a public record. Because if we have it in the government and when it relates to what we do, it is one. The right question is, does that public record have to be released? 165 exemptions in FOIA alone. Yes, ma'am, you had a question.
Yes. Does this extend to the court system here?
That's the perennial question, and the answer is anything but clear. I mean, you can't FOIA the judge's notes because they're a separate branch of government. But you can.
Specific, if you will.
Okay, sure. That's always helpful. This is a fact-driven law.
If I want to proceed in a litigation over $5,000 as a pro se person, it's going to cost me $600 if I want to e-file.
Okay, what's your question?
The question is, as we the people, as an individual person, am I, in order to get access to the information, which is all online now, it's going to cost me $600.
Okay, I hear what you're saying. This is not a FOIA issue. This is, technology is changing everything, and it used to be where, like our assessment cards about your house. Years ago, the General Assembly decided in its wisdom that we were going to put everybody's assessment records online. The law enforcement people were like, whoa, hold up. Online? Then somebody could find where we live and it could be potentially dangerous to me and my family. And we're like, those are public records in the courthouse all the time. But so now they're online because the way business in America is being done, they don't come to the record room and do title work. So this was a function of doing, so e-filing, you don't have to e-file. You have choice.
You don't have to have a telephone.
You know,
Do you understand?
I hear you, but it's clearly not a FOIA issue. It's not an access issue under the Freedom of Information Act because in Title 17.1 it says all records of the court are open. All case files are open for inspection, and you get talk about charges. They have a 50 cents a page charge. Nowhere else can you charge that, except the courts can do that. But FOIA about the operational expense, but all court records are already open. So trying to, I mean, there is a case in the Virginia Supreme Court about access to the big
How open are they
database.
if you can't access them?
Pardon me?
How open are they if you can't access them without payment? So freedom of information isn't free. It's expensive and unavailable to read.
I hear you, but I'm trying to draw the distinction between what is covered under the Freedom of Information, because, right, I've told you that they can charge. The court system for court records and filing is the administration of justice, which is a whole nother topic. I am sensitive to what you're saying. You know, it's about the money, but it is not a FOIA issue. And I want to keep pure to what the FOIA issue instead of general access-y kind of question. So that's kind of how it goes, reasonably specific. And I encourage you all to look at this because it just gives you some pointers about, you know, I tell the government folks, I use, again, myself as an example. I'm the general laws attorney and I do FOIA. What kind of records do I have, government, other government folks? And they have no, they can make an educated guess. So the point is, what do citizens know about what records government has? And so the FOIA Council has been putting, so we're not, you don't have to use the right words. Like we may call something different. And we're not going to control on that based on what you say. That's why identify the records with reasonable specificity. But FOIA is all about, on the record side, about being responsive to the citizens. There's a timeline that they have to follow. There is, when they say no or we need more time, it must be in writing. So we're not just making this stuff up, okay? So that's how it really works. I mean, what FOIA really is about. So, I stole this from my colleague Alan. Everybody raise one of your hands, okay? FOIA response time, 5 working days. Boom, we got it right here on our hands. 5 working days, okay? That's how you count it. Day 1 of the FOIA request is the day after it's received, okay? The day after, but 5 working days. Saturdays, Sundays don't count. Legal holidays don't count in the calculation. And in those first 5 days, the government is obliged under this law to respond. Please raise the other hand that you didn't raise. 5 responses. Look at that, you got the law right on your hand. 5 days, 5 responses. So you'll never go, how many days? 5 working days. First response. Sure, here it is. Second response. We need more time. Because what FOIA is about, and that you need to know, it's for records that already exist. Again, balancing need of government to function. The government doesn't have to create records in response to a FOIA request. Does not. It's for what's already there. And a lot of us as citizens, me included, we have it in our mind what that record should look like with the 5 data elements we're interested in. Well, guess what? The reality of that is there may be 45 pages of information that tell that story. But if the compilation hasn't already been done, FOIA does not obligate government to make a compilation. It's for whatever you got at the time. Now, what can turn FOIA into a mother on the government side is that they can go back in time, 5 years, 15 years, 20 years. So that's where that we need more time. That you've asked for 20 years worth of records. Or it could be just a FOIA request. I have a whole nother training about email. It's entitled Climbing Out of the Abyss. Email is counterintuitive in what it's done. When we all received email, and those of you, you know, it's true in the private sector as well as in the public sector. They said, oh, there's a magic button and it's going to make your life so much easier. You're just going to push that button and everything will populate. And if you want to do something, you just push that button. And on the government side, if somebody makes a FOIA request, you Just push that same magic button and everything will just pop up. Who buys that in this room? Most of you are all like, heck no, that's not how it works. So what I'm saying, it's private sector, public sector. So it's an abyss. So if anything, when you make a FOIA request, and again, I'm not offering excuses, I'm just a realist. I'm just telling you how it plays out. When you think, I want all the records, any emails between the members of the Board of Supervisors and the county administrator for 6 months. Let's just say 6 months. How many emails do you get in your inbox a day? Think about that. 6 months worth of emails, and how many members on the Board of Supervisors? 5. You see what just happened? It's exponential. And so instead of making it cheaper for the citizens, it's actually done the opposite. It's made it a crazy world for those of us in government that have emails, because we're getting 1,800 a year. And I'm not, again, not offering excuses, just the reality of the situation. Email is impossible to manage. And what it's done is made it more expensive. So when you want email from the government, you should think, uh-oh, it's going to cost a lot, because it's done. Just the search alone, trying to identify those emails that are what you want, okay? Yes, sir?
What about those of us that delete stuff regularly? Is that agreeable?
Well, I like to say FOIA is a statute about production of records. I tell people in the government, you could go back and you could delete everything and trash every file, and if you got a FOIA request tomorrow, the response under the Freedom of Information Act, those records don't exist. You don't have a FOIA problem. There's another law on government called the Virginia Public Records Act, which says, thou shalt not destroy public records. Okay, you got but you can't just randomly delete. I do write the Public Records Act, but that's all about retention, how long you have to, and so some emails under the Public Records Act is the idea that when government creates records or receives them, like the idea when you got your library card, you gave us stuff that we didn't have before. When you registered your children for school, it crossed over into the line on the government side. But, so the idea is they're available under the Public Records Act while we're working on them. So they're available to do our own work, if there's a FOIA request, to respond to a FOIA request. If there's litigation, so we can find them. So it's got sort of the active life, and then it goes into a dormant stage that has to be kept for 3, 5, 7, 9 years.
Are you
Yeah.
talking about incoming and outgoing? Are they treated equally?
They define a public record the same way FOIA does, which is anything that documents the transaction of public business. So it could be your correspondence, yeah,
Because we have no control over what email we receive.
True.
We only control what email we send out.
right.
So you say they're treated equally under,
The Public Records Act, in terms of there are schedules, how long they have to be kept. But there are certain things that say as long as administratively necessary. For example, when somebody calls me, I have a little steno pad and I write your name and your phone number. And when I call you back, I check it off. So when that steno pad is full, I can throw it away because it was as long as administratively necessary for me. But my phone records, if you call, and I'm actually not just listening to voicemail and I call you, I've had those for a long time. And so it's anything that documents the transaction. So it could be stuff we've prepared, it could be stuff that we received. But see, the public records definition under FOIA is related to the transaction of public business. So personal emails, when my husband emails me, yeah, he just started. He just learned to text 2 weeks ago. I got him a smartphone the first time ever. He's like not really that proud of himself. He's just, but when he texts me, even if it's on my government account, it's not the transaction of public business. Okay? So it's not FOIA-able, right? It's not a public record by definition. But, and then I want you to think about this. When you go, I mean, this is a small locality, Well, when you go into government buildings, what do you see on the wall? You see these plastic holders that have how to do this, how to apply to get your absentee ballot. You see all these things. Stuff is posted on the internet. So the government, in large part, is making public records available, or at least trying to. They're not, we're all human beings, so there's no perfect person in the room, right? Or in the world. And so the same, I'm Greek, of Greek descent. My guy used to say, I can't break my head to fix yours. And so we work with difficult people, we encounter them, and they're not all on the government side. There's some on the citizen side, there's some on the media side, it's part of our challenge as human beings to relate to one another. Because this is the idea of FOIA. Maybe that sounds completely naive to you, but that's what it's supposed to be. Hey, I want this. Okay, sure, next. Or no, that's exempt. We're not going to provide it to you under this section of the code. So that's the response. So first response here requires no answer. Now, be careful, 5 working days. Doesn't mean you have to have it in your hot little hands in 5 days. It means they have to respond by close of business on the 5th working day. So if they mail it to you, it may take a couple of days for you to actually get it. And if you actually come into the office of the government and say, I want to look at, you have the same FOIA rights as whether you didn't come. So it's not like, oh, we have to drop everything and respond to you. They can if they want, but they still have 5 days to respond to you. So yes, here it is, requires no writing. Now, we put a lot of things on the internet, and the question is, well, if you call and they say, it's on the internet, I want budget records. Well, it's all on the internet. Well, if the answer is, well, I want hard copy, then they must provide hard copy. If you respond, great, thanks a lot, then they're done. Because part of putting things on the internet or making publications available, public record, right, is to help out so that you don't have to. And I use, again, my Greek mother, telling my mother, it's on the internet. No, Mrs. Kissel, you can go to the library and get online. So, all of this humanness comes into play. Language is so imprecise. We in government have our own lexicon. As citizens, we don't have that same lexicon, but there's no requirement that we know. Only the requirement that we describe what we want. And let them help us get there. And yeah, there are some people that are hostile to FOIA, in the government side. I don't like that any better than you, because I don't like anybody giving government the black eye. Because I'm telling you honestly, I feel like most people in the government, whether they're elected officials, God bless them, because all of us who watch elected officials love to criticize, but at the same time, we're thinking, thank God it's on them and not me. And the more thankless job that I can think of in public service, elected public service, is being a board member on your homeowner association. But thank God they do it, So some of these things, when we lived in a paper world, it was pretty simple. You went to a file cabinet, you went like this. But with video, let's get personal here. Your son or daughter gets on an altercation on a school bus. You want to see the video, right? Because sweet little Susie would never have done that. So you make a FOIA request for the video. Okay? Prepared in the transaction of public business, public record, boom, yes. Okay, is there an exception? Well, it's your child, so you have a right to see what your child's involved in on that video. But the other child that they were fighting with, allegedly, that's their scholastic record. So the school system, under federal law, FERPA, says you've got to protect the identity of the innocents in the bus, of everybody else. So as the parent, you have a right to see video that shows just your child's action with a blurred or pixelated face and everybody else in the bus. You don't get to see because it's the scholastic records of the other child. But again, exempt from mandatory disclosure, but may be released in the discretion. They may say, well, come in and we want to, because you're the parent, we want to give you a chance to look at it, but you can't get it. So you see, that's how it kind of splits on these privacy-based kind of exemptions. So, yes, you can have it. Requires no writing. We need more time. If the government still has to, we call it the extension letter. In the first 5 days, they send out, it can be a letter or an email that says, it's practically impossible for us to search these records or to produce them in 5 working days. And the benefit on the government side of this is that by sending that writing informing you, they automatically get 7 additional working days. Automatically. You don't consent to it, you're not required. They get it.
On top of the 5.
On top of the 5. So it opens it to a 12 working day window, which is more than 2 weeks. And what we tell people, if you ever can't sleep at night, go online and read some of our opinions. I mean, they're most excellent. But, they're all in citation land and citing cases and all this other stuff. But the common thread is communication is key. Adversarial starting points are not good for the government, and I'm a cop's daughter. I learned early. Somebody gives you guff in your cop, you get right back in their face? No. Right? But we're human. Somebody does that to us, what's our inclination? To get right back. See what I'm saying? So communication is key. Do a little research. Talk to them. Because most of them want to help you out. Yes, sir.
Does the Act address items in the future, such as proposals and agendas and so forth?
No, it's for what exists at the time of the request. But you have magazines like the Crime Times and Gotcha that run the pictures of every misdemeanor arrest. They want, hey, give it to us, a month in advance because we're publishing. The government doesn't have to do that. It's for records that exist and go backwards, but never forward. But if it's, that the Crime Times is going to make that FOIA request if you're in law enforcement, you work out a deal. Okay, the check shows up, and here's your pictures, But yeah, nothing prospective. What exists. Neither, like I said, does government have to summarize or abstract from its own records. If we've made that compilation or aggregated something, then it is an existing record. But we don't have to create a compilation that you want. And if we do, then it's a different matter. Now we're not under the statutory duty under FOIA, we're providing a service. So we want to talk to you about what this is going to cost because it's requiring a little bit more. Okay? So the extension is automatic, 7 additional working days. Next 2 answers in the 5 involve the word no. 165 exemptions in FOIA alone, right? In our adult lives, it's about portion control. Hate that, right? I finally started liking food more, and now it's like, no, you can't eat that. FOIA land, it's about portion control. Just because a record has a little bit that's open and a little bit that's exempt doesn't mean the whole thing comes off the table. It just means those portions that are exempt come off the table. So the first response is, you're going to get some of this, but not all of it because some of it's exempt under this section of the code. Here's the rest. Or you may ask for, we want to know all the juveniles that were arrested in the city of Richmond, because your FOIA rights don't extend just to the county, the whole state. Then the answer is, these are juvenile justice records. They are prohibited from being released. We have no discretion. The answer is no. But they can't just say no. Again, the law requires them to put it in writing so that we're not making this up. And you can call us. We serve everybody. And say, is that, because so many of our opinions is, they invoked it as exemption, was that proper? And we'll talk about that. Hypothetically, Because our opinions, because they're advisory. I am not the FOIA police, okay? Our opinions are advisory, so these aren't the facts. This ain't the opinion. And we have that right now. We have whether somebody gave us a certain set of facts to write an opinion about, whether this incubator thing in Washington County is a public body. 2 days later, a citizen said, here's my facts about this incubator, give me an opinion. And the facts aren't the same. Well, what do? I have to assume good faith on everybody, but they don't match up. I am not the trier of fact. I'm not the judge. I write advisory opinions that are based on these facts, this is your answer. Based on your facts, this is the answer. Okay, so that's how the FOIA counsel stuff works. Fifth response. Has to be, well, I said no involves two. Yes, we need more time. You're going to get some, but not all. You're not going to get any because they're all exempt, like criminal investigative record. That was one of the original 5, and in Virginia, it doesn't matter if it's open case, closed case. It's recognition that the law enforcement mission is different. Yes, they have discretion to release it if they wanted to, some portions, but they don't have to under the law, and most cops do not. And I tell them, until people stop lying to the cops, then we would have a different world, and they would, some of that might be released. Final, that record doesn't exist. You're asking for something we don't have. Or we can't locate it. Or, in most jurisdictions now, when you call 911, you call the sheriff's office or the police department. Now the counties run a public service center. So the county operates it, but they give it to the cops to respond to your 911 call. Well, whose records are they? The county or the sheriff, who's a separate office? He's a separate public body from the locality. So if you're knocking on the door of the locality saying, I want some 911 tape records, and they say, you got to ask the sheriff because they're actually his. And that sounds a little like a runaround, doesn't it? A little bit? Well, you have them. Well, but no, you need to ask somebody. FOIA's not going to require that. But to say, other than we don't have those records, but we know who does, and this is who you need to ask. Okay? Now, qualitatively, I don't know how many FOIA requests are made in the state of Virginia every year. I know that I do a lot of training for the Department of Environmental Quality, who answer 1,600 FOIA requests a year. So, and again, it's not like, oh, poor government. No, it's an obligation. We all come in, well, once we find out what the law actually says. But that's what it is. It's about being responsive to citizens, providing records. Now, the difference between inspecting a record and getting a copy of it, inspection is not cheaper. Okay? A lot of people think, oh, well, if I just look at them. Because, again, all these exemptions, inspection right doesn't give you more. The same procedure of this part's exempt so it can be taken out. You're going to get still the blacked out version of that. So it's not cheaper necessarily to inspect, but it's a good way to start, kind of look at them and see whether you want copies or not of them. So let's talk about charges. What can the government charge you? And like I said, this is called cost recovery, not revenue generation. And when I talk to the government folks, I kind of do, it's important that we all understand how important this law is and have that aha moment. Because, again, on the government, we're on the receiving end of FOIA requests. So we don't look at it in the same way. But as citizens, individual citizens that work in the government, we see FOIA a different way. I was asked, who started the word transparency? Right, open government. Yeah, car dealers are now transparent. I mean, airlines, I mean, come on. But as a citizen, open government, I'm preaching to the choir here, we know what open government means something to the citizens. And even though I went to Virginia Tech, I will quote Thomas Jefferson, who said, if the citizens mean to be their own governors, they need to arm themselves with the information to do it competently, right? And think of that. We're all citizens. Some of us are government. How many people in here are the government? Okay. Yeah. Do you like thinking that people think you're a bunch of bums and that you're asleep at the switch or you're stupid? Because that isn't the case. But I use myself as an example. I have 4 dogs. I walk them way early in the morning. Most of the time, I just put on pajamas and walk them. And sometimes if it's cold, I got dog walking clothes. If it's cold, I got this hideous hat that I put on. I inherited a Shih Tzu from my mother-in-law in Washington County. Her name is Eula May. Little Eula May is 15 years old. She can't walk 2 miles like the big dogs can. I bought a papoose. And Eula May, when she gets tired, goes in it. Okay? Right? I was doing pretty good till that, right? So imagine what I look like in this one of those ski caps with the braids rolling out, with a dog head sticking out in the middle of my chest, in my slippers and pajamas, and sometimes I'll put shorts over my pajamas. I mean, it's a sight. When I come in, after I brush those dogs and feed those dogs, I put on the uniform and I turn into the government. That's kind of scary. Because we talk about government of and for the people, right? The great experiment that was started over 240 years ago. What does government of and for the people mean? We all like it, right? Everybody thinks, yay. What does it mean? Okay, if we think about it, we elect people. Yay, got one. After that, what? We're regular citizens. And we're the government too. And so again, here's crazy Maria walking dogs in the morning looking like, oh my gosh, she escaped from the asylum. And when I put this on, I'm the freaking executive director of the Freedom of Information Advisory Council. Paid to give people opinions. Isn't that freaky? And for you people, raise your hand in the government. We're just regular folk like everybody else. So can't we be nice to each other? We're on the same team. We're really on the same team. And I said, it's in writing, 1-5 rule. If you get bit by the government, then you don't have to be nice anymore. Okay? You don't have to. But it's not an adversary. It's not supposed to be an adversarial process. And again, take into account that it's ignorant. Yeah, there are penalties under the law. The law says, failure to follow any procedure under FOIA is deemed a violation. So it's a big government of by for the people kind of law. If it's we're the government and we're the folks, then what government of by and for the people really means to me is the freedom of information. If it's really our government, then we have a right to know what we're doing to others, what's being done to us. Because then the idea why it's records, not explanations, is that we get the record and then we call our elected official and go, what the heck did you all do that for? It allows for political action. You're knowledgeable now. You have something that you have a reason to talk about. Okay? That's the point. But it's really supposed to be a semi-permeable memory. Most stuff comes in, and everything comes in, and most of it comes right back out. But FOIA tells us, on the government side, if you're not sure whether it's an open record or not, you default to openness. The thought of just going, I'm not really sure, means it's open. You always default to the open side. So those 900 training sessions, we're talking to government. The press did another audit in 2006. Virginia's compliance rate was 50%. Certainly a lot better. I write gambling law. 50-50 chance of getting it right. Not great. But now the FOIA Council has passed legislation that requires every level of government to name a FOIA officer. Somebody in the body that knows a little bit more than the rank and file. So can recognize, oh, that's a FOIA request, somebody needs to know. And so to help citizens, now there's a rights and responsibilities document at local government and school boards that says, citizens, these are your rights under the law. These are the kinds of records the building department has. These are the kind of exemptions the law gives us. And this is how we charge, based on the law, okay? So we're trying to make it formulaic for government, and also you understand the big picture. But for the people that come into the government, especially from the private sector, and it's like, you know, they've worked for West Vaco, and it's like, somebody asked for this, I gotta give that out? Well, if you went to West Vaco, they'd probably push a button on the table and you'd shoot through the floor and out and on, you know. The public side is way different than the private side. You know, we do lay bare, except for those exemptions, but again, it's not mandatory that they use them, but they're available for the government because it's recognizing whether it's a closed meeting or an exempt from mandatory disclosure record, it's still in the public's interest that it be kept close to the vest. So this is a procedural law. That's all it is. You make the FOIA request, they respond, they move on. And that's it. Yes, sir?
Or can one find a retention schedule?
You can go to Library of Virginia's website. They have a records management website that tells you like payroll records have to be kept this long, and so it's online at the Library of Virginia. And you can actually, they come out and do training as well on record retention. Anybody else have a question? Yes, sir. Yes, ma'am.
Hi, I'm the registrar here in Rappahannock County. My question was a little bit about, you know, after that additional 7 days and dealing with intimidation and threats, etc. I mean, for example, this happened in our office. There was this organization out of Illinois that demanded these records.
Is that Smart Procure?
Huh? What?
Is that Smart Procure?
No, PIL.
Okay.
People for the
Whatever.
Legal Foundation. Anyway, they wanted this certain report to skew information that would affect voter confidence. And, you know, we operate under the Department of Elections, and there are laws, like we can't, we have LEOs, law enforcement officers, who have to have a different address, those addresses, I mean, there are just all sorts of additional things that we deal with. But this organization asked for these reports. The Department of Elections said they gave them to them. This organization said they did not. I was advised locally that I didn't have to provide the information because the people requesting it have to be registered voters in the state of Virginia. And this organization was in Illinois.
Okay.
So I didn't respond. And generally speaking, the Department of Elections always handled these things and protected the registrars. They are not doing that anymore. So there were registrars who were sued. And there were registrars like myself who was waiting for the Department of Elections to tell us what to do, you know, whether these records were exempt or not. And finally, I ended up having to, you know, print the report and send it, but it was well after the 7 days. But I mean, my point, and they showed up, two of the representatives showed up on the first day of absentee voting for the presidential election and stood in my office demanding the records. After having requested, you know, in a letter. And as soon as I said I was, you know, speaking to our county attorney to get advice on it, they left. Like, they wouldn't give me their names, their phone numbers, anything. But that's intimidation, you know?
Well, I hear you, and I've had a similar experience. I disagree that, you know, people, we're the big bad government. People can't intimidate us. We can intimidate others. Now, you can harass us, that's for sure. But a couple of things. Remember I started with, there are myths about FOIA? One of the myths is you don't have to be a registered voter in Virginia to make a FOIA request. You just have to be a citizen, whatever that means. You
Under,
live here.
under NVRA, they do, the National Voter Rights Act.
Yeah, okay, but you know, that's another law. It says election law and voter law, Title 24.2. It's all subject to FOIA except if they're in conflict, 24.2 controls. And so you sort of see the problem of, I'm not sure what I'm supposed to do. And so you can call us now and we'll help you out. And we have a pretty good direct line to the state board of elections. So we can help you out there as well. Now the question, out-of-state requester. What does Virginia say about who has rights under FOIA? Citizens of Virginia, whatever, whoever they may be. We interpret that as they live here. That's a pretty easy one. Well, that sounds pretty easy. What about students at higher ed? You see how it can get kind of really falls apart and there's like, we're not sure. I mean, I tell people they live here. They live here 9 months of the year. And media that broadcast in or out of Virginia or have circulation in or out. So the Wall Street Journal has FOIA rights in Virginia. But somebody in Illinois does not. This went all the way up to the U.S. Supreme Court because Virginia is only one of 5 states, see, 5 again, that controls on citizenship. Every 45 other states don't care where you're from. Which is, yeah, I don't even know how they're doing that. You know, because some of these requests are like an email request for somebody in Illinois. How are you going to collect the money? I mean, you're spending the state of Virginia's public money to respond to somebody. So the state, I mean, not state, the U.S. Supreme Court said Virginia's law limiting it on citizenship in media is completely constitutional. So we extrapolated from that. This is a law of minimums. You can always do more. What we tell people, when you get an out-of-state requester, the law doesn't apply to them. The U.S. Supreme Court said so. What it is really code for is citizens of Virginia and the media are the ones who can sue you for a violation, failure to follow any procedure. They respond in time. But even, there's always a deal can be made, and the timelines. But what happens with the state requesters for those in government? You could tell them, the law doesn't, the law doesn't apply to you, go pound sand. Not a nice thing, but what can happen then, what that sets up is we call it the end around. It's not a football term. Somebody's related to somebody in Virginia, right? Somebody went to school with somebody in Virginia. So to us, the law doesn't apply to somebody in Illinois. So the best thing is like, we'll get it to you in a reasonable time, but we need the money up front. They can't do that. We can't do that except more than $200 to anybody, citizen or media. We have to go through the drill. Out-of-state people, what it is, code. They can't sue you for a violation, so you make it work. I got a call from the Racing Commission. They got an out-of-state requester. They said, we get to tell them pound sand, right, Maria? I'm like, yeah, you can. That's your right under the law, because clearly it doesn't apply to them. I said, but they're going to do the end around. And they're like, well, we're a gambling agency, so we're going to gamble with them. You got to love it, right? And I'm like, call me when they do. 10 days later, boom, they got a FOIA request from a citizen for the same, they found somebody. And now they're in that 5 working day response time, put it in writing when it's required, charge only that. So with out-of-state people, those rules don't apply. We want the money up front. We're not spending our public's money to help you out in Illinois. But we'll get it to you when we get it to you. But yeah, the whole intimidation thing, it's, some people are just mad. And the best thing I tell people in government is just, motive is immaterial. Why they want it, we don't care. It doesn't change anything for the response times. It doesn't change anything. We don't care why you want it. This is a right-to-know law. This is that big government of and for the people. This is that big experiment that's being carried on in America. And so the idea is you can always make an arrangement for something else. And we got a call once, it was from a reporter. They called statewide election times, and the Library of Virginia has archives of all campaign financing documents and blah, blah, blah. I mean, tons. So people are making FOIA requests because they want to do some on the incumbent. You know, you've seen it when the sheriff runs for election and somebody makes FOIA requests to the new guy to see if they can assault, you know, cast aspersions on them. FOIA has many purposes. That's one of them. Where's the American flag? Grist for capitalism. I mean, FOIA is a big, kind of tied up in America. And then I just lost where I was going with this. So I'll come back to it, I'm sure. But yes, sir.
Could you discuss closed meetings and meeting announcements?
Okay.
That's been a particular issue.
Yes. The law says on the meetings law, if it's a meeting, and we can talk about what the heck a meeting is, it requires three things. Notice to the public, open to the public, and minutes. Okay? Closed meetings, what I love is the media always writes, oh, the Board of Supervisors had 37 closed meetings this year. Who cares? If it was lawful, it doesn't really matter. It's not the number of meetings, are they complying with the law? Because that same thing about protecting public position, the exemptions from mandatory disclosure, and the meeting side are called closed meeting discussions. They talk about, say there's a risk management issue. Somebody got hurt playing at the public park. If you were the person whose child got hurt at the public park and you knew that the county could pay you up to $2 million, that's how much they set aside, how much would you ask for? Right, you see? I mean, you see the need and the desire. Again, it may not look to you like, yeah, Maria, you're full of it. You're talking about protecting the public position. We are. That's sort of what closed meetings are for. But you have to go into a closed meeting properly. Again, procedurally. And open meetings, closed meetings always occur in the context of an open meeting, because you have to make the motion in public to say, we're going in, and the law requires 3 more things to close a meeting. The code site, a statement of the purpose of the closed meeting, and the subject of that closed meeting. Now, we're all like human beings. Subject, purpose. Sound like kind of the same thing, don't they? A little bit? Not to you? Well, good, because you're right. When I thought purpose, subject, that's kind of like, isn't that the same? Or kind of the same? But when you look at it, the code section that authorizes closed meetings, and there's 46 of them. One's economic development. If we're trying to bring somebody into the locality, we're not telling you who they are until the deal has been struck. And then you get to see how much money we're giving them or whatever else is going to happen. We do it for legal advice. We do it for buying and selling real estate. But the code section in FOIA that says, you have to say code, purpose, subject. And a mere reference to personnel is insufficient to close a meeting. And so what happens is, you look at the law, and it's 2.2-3711. And the catch line says purposes for which a closed meeting may be held. So the law gives you 2 out of the 3. You got to come up in the government with what the subject is. And the subject and what the mistake has been made over and over again is, like the real estate closed meeting exemption says, the discussion of the acquisition or disposition of real property where discussion in an open session would have an adverse impact on the public body. Okay? And so they cite that. All you got is a bunch of purpose. There's no subject there. And the subject is, again, a balance. You want to let people know why you're kicking them out of the room, but without giving away the store. But let's use the school board. they're going in under personnel to discuss the disciplining of a high school principal. So personnel is the purpose, discipline is the purpose, high school principal is the subject. I grew up in the city of Alexandria. How many high school principals do you think there are? Am I disclosing which one? No. In Rappahannock County? Boom! What did you just do? And the personnel exemption is a privacy-based exemption. So the school board wouldn't have to say the disciplining of a high school principal, because then everybody go, oh, it's you and you're in trouble. So what they could say is the disciplining of a school board employee, because everybody works with school boards. So it's got a little bit of subject, but enough to go, okay, in the real estate context, is buying land for a park. Do they have to tell you which parcels they're looking at? I already told you why they wouldn't, right? Because then you'd be mad because you paid a lot more for it. Okay, so that's how closed meetings work. And what happens with the minutes, if the motion is improper, it is documented in the minutes. The violation is documented. Like I said, the law says failure to follow any procedure. So on the meeting side, giving notice. You didn't give notice, you violated the law. You didn't give a subject for the closed meeting, you violated the law. So you, as a citizen whose rights were violated, the government, by and for the people, right? The big one. You have a right to sue your government on that basis alone. The answer, too late. But again, from the government side, we sort of cringe and go, because most of them are dumb mistakes. You know, we have a provision for willful and knowing violations, but most of it is just like ignorance. I mean, we're doing a lot to try to, no, this is what the law says. Government, do what you're supposed to do. It's not you named the public body. So it's the Rappahannock County Board of Supervisors. That lawsuit doesn't come months down the road. When you file it with the clerk of court, 7 days it has to be in front of the judge. So we all know in this room why it's important, but more symbols, and the burden of proof is on the government to show we comply. You as a petitioner saying you violated my rights because you closed a meeting and it was improper. That's all you have to do is allege that. You don't have to prove jack. The government has to say, okay, this is, Your Honor, how we complied. And if the government fails to meet that burden of proof, then you win. And you're entitled to recover your attorney's fees and costs for making the government do what it's already supposed to do under the law. And as I tell the government folks, does that make any sense? Because usually the people who are going to sue you are not your favorite folks anyway, right? So does it make you happier that they brought you to task and you got all involved emotionally? Because this is a law of how we in government have to act. We don't have to love you, okay? Right? This is not how we need to feel. We're just human. So if you get all emotionally involved, you're probably going to violate the law. And does it make you happier to pay people who you didn't like in the first place $15,000 for making you do what the law already required you to do? No, we don't have that kind of money. So we need in government to wise up. And like I said, I hope you don't interpret what I'm saying as excuses for government, because nothing could be further from the truth. This law is a win-win law. The government is in compliance and the public is served. It's a beautiful thing. It's just, we get human beings involved. Oh, good God, then what happens, right? And so you got to keep that in mind when you do. It's not always gotcha. It's not, again, we're just human. People do that too. It's not a good thing. So, pardon me?
Sometimes it is a gotcha.
Yeah, well, and that could be, my favorite forefather, James Madison, he said a lot of good FOIA quotes, but this one is, bad cause seldom fails to reveal itself. So it's going to come out one way or the other. So FOIA is like, we don't care what the motive is. You want it, you get it. And most people in government are doing a competent professional job. There's no reason for gotcha. I mean, if somebody's going to slant it and misrepresent based on what they receive, then they're slanting and misrepresenting, right? And on the security thing, some of the government things like, yeah, I call it, well, we don't want to release this because if this happens and then this happens and this happens, this bad thing could happen. I call it the age of Aquarius argument. When the moon is in the seventh house and Jupiter aligns with Mars, then peace will guide the planet. That's not what FOIA is about. You can't, right? So we've got a lot of training to do in the government side, but we think about everybody that it has to do. And there's no training. 17 years, that's when the training started. Now we've made improvements. There's a FOIA officer for every locality, for every public office that you can talk to. Now you have to know who it is. It's going to be on their website, or you can call us. And they're going to know. So you don't get people, I went to Henrico County. I have this big information desk. I asked a question. He said, I have absolutely no idea what you're talking about. It just doesn't look good for the home team, does it? But, you know, you have people that are hired in different things, and were hired to be a dispatcher. They were hired to, you know, scan documents. But somebody, if they're on the front line where somebody could say, hey, I want these records, they're like, what? Right? But now the point is, there's some internal thing that happens in localities and state government that, they at least know enough to get the FOIA officer. So your compliance, our compliance will be better because we're trying to do things to serve. And the FOIA officers have to be trained. And anybody in the government that raised your hand, are you a FOIA officer? You have that. Okay, good, because this counted as your annual training. And we would have given you a certificate for it. Yeah.
Is there any kind of exemption if you're under a certain size as a municipality from that?
On FOIA, yeah, it's under 3,500.
Oh, good.
I think so, yeah. I have the law, you know, in doubt I can read the law, but we copied it because, like, procurement law makes some distinction if you're a town under 3,500 that you don't have to do certain
There
things.
are
Yeah.
other things where we're exempt, I was just wondering.
So, yeah, I think on the FOIA officer, I think it's the rights and responsibilities part. But I'll have to look, I mean, I can look right now,
And so,
but there is a size. There was a bill in the General Assembly that said, if it's a small locality under 3,500, they get 30 days to respond, because you got one person doing like 57 things. That went down the tubes, as you can imagine. Because we tell people, you know, FOIA sets out the process, 5 days, right? 5 responses, but you can always make a deal with a citizen to do something else. Oh, that's where I lost my train of thought. Campaign finance records. The call came to us. The Library of Virginia is trying to blackmail us. I'm like, really? How are they doing that? We asked for records, and they said, it was hard to believe, but it was true. They only had one copier in the Library of Virginia. And anybody in here a genealogist? Yeah. Okay. Let me ask you, ma'am, what are the chances if you're standing in the next in line for that copier at the Library of Virginia, that if somebody in the government came up and said, could you move out of the way so we could make... A genealogist is not going to give up their position. So what they said is, we got genealogists here. They don't get out of line. It ain't happening. So how about if we give you, and we got oodles of campaign finance documents you're looking for. So how about if we give them to you 25 pages at a time over the next 2 weeks, because we can't elbow out the genealogist, and we'll cut our charge. I'm like, do you know what blackmail, the technical definition of blackmail? That was not blackmail. They were trying to make a deal with you. So be open to that because it's to your advantage. Work it out with your fellow human beings. Okay? I mean, again, one bite rule. The law only requires one bite from a dog or from the government. One bite, you can be as ugly as you want. But realize it may work for you, it may not. Okay? Yes, ma'am.
How long does government have to provide minutes of a meeting?
Minutes, we're looking at that again at the state level. If you are, well, to provide minutes to you, it's 5 working days, assuming they've transcribed it. But see, minutes, if they do a recorded thing, you have a right to ask for a tape. But you don't have a right to say, I want you to transcribe that tape in 5 days.
So they have to be taped?
No, they don't have to be taped. No, but if somebody is, so for minutes, the requirement is, it's like any other FOIA request. You want a copy of the minutes, you make a FOIA request for it. So it's whenever the minutes are done. But the law recognizes the distinction between executive branch agencies of state government, because that's where, you know, all the regulatory boards and stuff are. So minutes have to actually, draft copy of minutes have to be posted within 10 working days, and then final approved minutes have to be 3 days later. But that's executive branch of state government. The local level, no requirement for, they all post minutes, is our experience, is everybody posted, it's just they can't meet a timeline. Yes, ma'am.
Well, there are months of minutes that's not being posted or anything.
Well, there's no requirement for it at the local
So they
level.
don't have to.
They don't have to post
provide
them.
minutes.
If you make a FOIA request for them, yes, you just ask for them. But there's no requirement at this moment for local governments to post their minutes. But like I said, most of them do. They have a minute book, they post minutes. But if they don't, you can make a FOIA request for it. Yes, sir.
On this point, what are the implications of something being videotaped, if that's the right word? So for example, in this county, the newspaper now, didn't used to, records every public meeting, most every. And it is available for public access through the newspaper within 2 or 3 days. That's a better, if someone wants to know what went on in the meeting, that's a better document, one would think, a better practice.
Right.
Than the minutes of that meeting, be they 2 pages long or 100 pages.
Right.
I'm not suggesting one doesn't do minutes, but how does the law work, and maybe beyond FOIA, is to how we use the
Okay.
I mean, if you say, someone says, you didn't do the minutes, and somebody says, look on them,
Yeah.
no, look, you can see it, you can see the whole thing, spend 2.5 hours to see every word.
Right.
What are the legal?
Okay, the legal issues, FOIA says anybody has the right to film, photograph, or record a public meeting, the open parts. So if the newspaper's doing it and they're posting online, you're right. Having the video is great. Is a requirement on the government to actually record it? No. They can. Some people take minutes like, this is how it's, you know, kind of. Some people, the clerks who take the minutes, and, you know, I am the executive director / clerk of the FOIA Council. Guess who takes minutes? Guess who writes those minutes? If I knew shorthand, I would take those minutes in shorthand. And so if the FOIA request says, I want the handwritten notes that you know, the handwritten ones, okay, here they are. They're in shorthand. Good luck to you. They're not trying to be, you know, I mean, but, so the idea is anybody can record it. The government's not required, but the idea with minutes is that minutes, the law says what has to be in the minutes. Who of the body was present and who was absent. It says a summary of anything discussed, deliberated, proposed, or decided. Okay, so votes. I go the rule of 3. 3 sentences about what somebody may have said. It's a summary. It's not a verbatim transcript. And what happened is, in the school board setting, technology has this thing called board docs that you can launch a bunch of junk in, the agendas, all the materials, and they're like, well, then we don't have to do minutes because this is up before the meeting even occurs and people can go and access, again, think of my Greek mother. Yeah, it's all on the internet, not helping her. And they were saying, well, we don't need to do written minutes because it's all there. And we're like, yeah, no, that's not going to work. Because how do you do your own business to make the public or you navigate through hour-long, hours and hours of meetings? That's not helpful for your purposes or for the public's purpose. Minutes kind of focus you in on a particular issue. What was talked about an issue, and that's why you would look for minutes. So there is no requirement to record under FOIA, that the government is not required to record an open meeting. It can if it wants to, but you certainly can, and you have a nice service where the newspaper is doing that. But minutes is still about a summary document. And let me show you how this gets dicey. Some board of supervisor meeting, and all these examples, they're questions that came. So I'm not making any of this up. Somebody said, one of the board of supervisors somewhere, city council said, when we go into closed session, I think we should have a guard at the door. And the attorney went, yeah, that's a bad idea. And they moved on. The next day, whenever the minutes came out, the citizen who was in attendance at the open meeting said, this discussion was happened, but it's not in the minutes. Is that a violation of FOIA? And so my question to you, was that an issue that was proposed, or certainly was proposed, I think, decided, deliberated? So you see how mushy it can kind of get? But the law gives you constructive. When in doubt, you open it, you put in more. But that's part of just how the law is trying to put out ideas of openness, ideas of a democratic republic, values that we all use, but can't get into the weeds. Sort of when you run out of time. Can you work a deal then? Sure you can. But does the law say that? And what if it's, you think you have some meeting of the minds and it's like, no, that's not what I wanted. And I've got 37 copies of the same email. Why did you do that? Well, if we parsed them out, then it would cost you more for us to pull them out. I mean, it's just email bad for so many reasons. Yes.
So, I'm just,
Go ahead. Sure.
So minutes are required.
For deliberative
For
bodies.
sure. Pardon?
Deliberative bodies, like the local board of election. They're the ones that have minutes.
So other boards and councils.
Everybody, any
Right.
deliberative. Right.
So minutes are required, but there's no time frame. Like you can't FOIA request, like you already said, you can't FOIA request something that doesn't exist yet.
Correct.
So you could not take minutes for 5, 10 years and there would be no.
Well, but the law requires minutes. It just doesn't say when they have to be done. But I think if you show a pattern, if somebody asked us for an opinion that said they don't prepare any minutes, because part of it is the deliberative body has to approve the minutes at the next meeting. But if somebody's like, but minutes are required, they are required under the law. So the fact that they're not doing minutes is a violation of the law. And this is America, and how do we exercise our rights? Not the greatest. We take people to court. Yes, sir.
I was under the impression that if a body chose to videotape and use those videotapes as their minutes, they have to file those, they have to maintain them, keep them. But they weren't required to write them or transcribe them.
That is not correct.
Okay.
If they record, because FOIA requires minutes, written minutes, because of the board docs were like, we put in recommended legislation that said, no, minutes have to be written.
But if if the board decides to tape, they are then required to maintain that tape.
under the Public Records Act, which I was trying to say I don't know that much about, the rule on taping is if you record the meeting and then you do the minutes, then you can cover, you don't have to keep the recording because you have the minutes. Once the minutes are approved, that's the official document of what happened. They're not required to keep that tape or audio tape, videotape. But written minutes are always required. And if somebody's not doing written minutes, then it's a procedural violation. They're all procedural violations, and you have the right to sue them on that behalf. Questions, anybody else? Yes, sir.
Clearly, you have a right to bring it to court and have a judge tell them that there's been a violation. Beyond that, what are the other remedies?
Okay, so the remedies are the judge, if the government doesn't meet its burden of proof, then whoever sued you to make you do what the law requires you to do is you're entitled to recover your attorney's fees and costs. Then the law has a little more teeth in terms of if the judge finds that the violation was willfully and knowingly made. I don't like her, I'm not gonna do it, I don't care. And in my tenure, only 3 times has the judge assessed a monetary penalty for a willful knowing violation, and unfortunately it was always the sheriff that said, I don't care what the law says, I'm not releasing these records. Now, I'm an attorney. If he was my client, I'd be like, I wouldn't be saying exactly like that in court, sir. But, so, there is sting. So if the judge finds that it's a willful knowing violation, you knew it was wrong and you did it anyway. Up to $2,500 for one violation. We don't do minutes because we're not going to do minutes. That's a willful knowing violation. For any second or subsequent, up to $5,000. So yeah, you're all right. This is a huge, important law.
Individual person found guilty of that liable, or is that a expense against the municipality?
No, it's against the bad actor.
All right, so it is personal.
Right, it is personal. For the other just violation, it's against the body, but a willful knowing is against the bad actor. Okay? Yeah, so it comes, again, you're in court quickly. And if you decide, we have FOIA petitions on our website to file in the circuit court, general district court. And what the law requires is that you give a copy. It's not service of process. If you're going to sue Rappahannock County, then you give somebody a copy of it before you get, at least 3 days before it hits the judge, because once it's filed, 7 days you're in court. And why that happened, it was in Prince William County, it was the winter holidays. And somebody just wanted to do sort of the gotcha, and filed a lawsuit the week of Christmas. Well, they didn't know anything about it, and 7 days they're in court. So the law changed and said, you got to at least notify the people you're suing that they're going to be in court, So some of this is, as you hear it, it's like very pragmatic. It's, it's trying to take into account human interaction, but it's the idea here is we're all on the same team. We're all Americans. I think this is my crazy Maria thought. We will all be united as human beings once we know that they're extraterrestrials. Then nothing will matter. If I'm lying, I'm dying. It's true.
I didn't hear what you said.
Oh, I said the planet, all of us human beings will be united once we know there's extraterrestrials.
Yeah, okay.
I mean, then it'd be like, yeah. I thought I didn't like you that much, Patty, but you know what? You're excellent as compared to alien dude, right? Just an aside. But so much, I feel like I'm a counselor in a way because it's, just adversarial is not the way it's supposed to be. And like I said, we're all citizens. If I was always told, ask the question conducive to the answer you want. I want the records. I'm not going to say crappy things to you or insult you and think that you're gonna jump to attention and serve me best, you know? But sometimes it's warranted. One bite, that's all I'm asking, you know? Approach people respectfully, you know? That, you know, and I was thinking about that riding up here thinking, yeah, you pay my salary and I thank you for that, you know? Everybody in the state is paying me to drive up here and appreciate that. But, you know, it's interesting, well, we get you because we pay your salary. We get to micromanage you, we get to do all these things. And it's like, yeah, no, I'm in public service. But also, on the private sector, this is the part I was thinking about. Aren't you paying those people too? Really? And you get as crappy to them as well? I mean, you know, because whatever it is, Verizon, you name, whatever we're paying somebody, are we paying all of the people who work there with our stuff? So I'm just encouraging people to, like, you know, sit down together, sing Kumbaya, but understand that, you know, it's all about communication. And that's a hard nut sometimes for us as human beings, but it's really the free flow. That's the whole point, is what do you got? You know, I want to see it. It's important. And there's ways the law tells us that's important. So closed meetings, again, procedurally. And so this law is all about process. You know, how the government is responsive to its citizens. And for the citizens in here, there's no right to make public comment at a meeting. It's eyes and ears kind of thing. But most of them offer a public comment period. But they can't say, okay, we don't like you, you don't get to talk. But we like you guys. Yeah, can't do that kind of crazy stuff. So with the public comment part, there's other ways to reach your elected officials. You can send them an email and be part of the abyss. You can make an appointment and go talk to them. You don't have to like air your stuff at the public meeting. That may not be the effective use of your time to rant and rave or whatever it is, because it may not even be an agenda item, right? So there's other ways to reach those folks. And then other technology issues that FOIA is, we're going to grapple with. We're still studying it, and I encourage you, the FOIA Council meets Monday. We're going to have a meeting on technology. We're having a meeting, you know, to deal with all these technology issues. Board of Supervisors sitting up here, this happened, I think it was in Loudoun County. Texting, members texting others. That's like a meeting within a meeting. And old school, it was, if they were having a sidebar conversation, we all could see that. I mean, I work for the General Assembly. I love when people get up to make public comment and they're like talking amongst themselves and the people stand at the podium and they wait. I'm like, yeah, no, just let it out, you know? You're waiting for them to pay attention? Yeah, no, that's, I mean, but at least the sidebars were visible. So most of the people that give testimony in my committee look at me because I'm the only one looking at them. And it's, again, respectful. You know, yeah, stuff happens, you have to have sidebar, but texting now, the way it was with this, you could see it. Most biases are like this. You can't see what somebody's doing over here, and that's what happened, is they were texting, it was a subcommittee meeting, and they were texting the person who represented this jurisdiction who happened to be out of town. Are you still opposed? And at least they said, we're texting. And the attorney said, then read it into the record. And so how do you solve that problem? Say you can't text? Can't have your phone if you're an elected official? That's crazy. Because there may be something dire happening at home that you need to see what's going on.
We don't have that problem, we don't have cell
Well, see, there you go. You know, when you're winning, sometimes you're losing some other times. Yes, sir.
Could you explain at what level within, let's say, our county government do we require FOIA officials of some sort?
I'm not
In other
sure.
words, does the Board of Supervisors require one person to be named the FOIA specialist for them?
The FOIA officer, we let them, it said each public body. So, in the local governing body, the Rappahannock County, the public body is the county, because you got every part of the county. So the county can do one or more. They could say, we have a FOIA officer for the Board of Supervisors, we got a FOIA officer for the building department, we got the sheriff, or they can just have one. Because the public body in the locality sense is the locality, except for the sheriff, who's a separate political subdivision, and the school board.
So constitutional officers don't have to have their own.
Yes, they do.
Oh, they do.
Well, I answered that too quickly. They could make an arrangement with the locality that they're served by the locality as the FOIA officer, or they can have one in their own office. So
And your office provides training for them?
yes. Yeah, most of that 900, when my husband's like, when I told you it's odd, you're going to go talk to a bunch of citizens, I'm like, I mean, it's true. I talk to government most of the time, and I really like it when I talk to the folks, because you guys don't know FOIA any better than anybody else, Again, getting rid of perception, what is the law? So yeah, we come wherever, because I think the training mission is the most important thing. Because all of us, all right, who knew anything about FOIA? I mean, what FOIA ever said? Who actually read the statute in this room? Okay, look at you. Go ahead.
Does intent to work?
Yeah, see, I hear you.
Your head hurts? Is that-
Yeah, I'm with you on that, But you see, it's a law. And when do we all sit down with the law, whether we're citizens, the media, or even the government, to sit down? Oh yeah, my spare time, I'm gonna pick up a 60-page statute and just leaf through it. I'm with you. So that's what the training is all about. We will come, I'll come back, we'll go anywhere, it's free of charge. Because people are like, Maria, you gotta quit traveling and just do webinars and do all these other things. I'm like, no, because you got to talk to the people. You got to make a connection to the people so they can ask their questions. A webinar doesn't really give you that. Yeah, that might help some other, but yeah, I'll do some of that. But go and talk to the people who are involved, whether on the citizen side or on the government, of what the requirement is under this law. And it's about responsiveness. Plain and simple. Yes.
Can costs be collected for electronic documents provided pursuant to a FOIA?
Yes. What charges are allowed? The law says a public body may assess a reasonable charge for its actual cost. Thank you. Reasonable, actual, in the same sentence. Okay, what's the important word? Actual cost recovery. Electronic documents, because what you can charge for, actual cost in government is tremendous when you think about it. We own the buildings, right? We own everything in the building. We do the heat, the light, the air conditioning. Who's this we I keep talking about? We the people, okay. So clearly we can't charge that because the people have already paid that. It's for searching. So to the extent they're providing to you an electronic format, because that's what you ask for, they still have to be searched. So it's the hourly rate of the person doing the search. Accessing the record, which I still, in today's world, it's still searching, because it's computer. When you go into a database and do a word search, you're not creating a new record. You're not even abstracting or summarizing, you're extracting, right? You're extracting. And let me just tell you, because I think about this stuff all the time, databases. I live in FOIA land. It occurred to me 2 years ago, okay? 15 years ago, there's not just one database for the county. There's several databases for the county. And not everybody has the same level of access to those databases. We on the citizen side is like, what? You see how it gets? Electronic records have kind of made it all kind of crazy, in a way. In legislative services, we have a bill drafting database. Only the drafters have access to that. You know, the FOIA council, we have a database. So it's not as easy as my favorite FOIA request so far was, not to me, but to the city of Fredericksburg, no, to the Planning Commission. We want all electronic records that have the word staff recommends. What do you think? If that was you, you'd be like, and they called me and like, Maria, come on, is that reasonably specific? And I'm like, it's a electronic record. You search, staff recommends. Boom, it's there. But the rest of the request went, and this should only take you 15 minutes and cost me $15. I said, you just thank them for their vote of confidence. Because that's not, people look, why do they charge? And back to charge. Searching, accessing, which is getting your hands on it. Supplying the record, which is the time to redact what the law either requires you to take out or allows you to take out. Or if you burn a CD, the cost of the CD. If you mail it, the cost of the postage. And then duplication charges. So there's a formula in here. Because the government needs to know how much it costs to run a piece of paper through the copier. Because it's an actual cost. And it's like, well, why can't it just be like a dime, like Kinko's? And it's like, because we're not Kinko's? That might be a big one. But we got to know what it costs. And case in point, some lady requested from Southwest Virginia somewhere these records, 1,000 pages of record were provided to her. Nothing was withheld. They charged her $300. What do you think? Good, bad? Don't know. How can you assess that? It's like 30 cents a page. They never charged any labor search costs. They just did a straight copying charge. They waived all the other stuff. And so I said, well, you know, I don't make the call on reasonable. Is that actual charge reasonable? But I did call the locality and I said, okay, 30 cents a page, is that what it cost you? And it's like, I don't really know. That's what we've always charged. Yeah, that's never a good answer. It's the Virginia answer, but it's not a good one. So I said, okay, let's use this little formula we came up with and stole it from Connecticut, from their FOI law. I'm not good at math, but we sat down and we did toner, paper, to how you figure out what it costs. Because we can't set a charge because do you own your copier or do you just have a maintenance contract? You know, the cost, so it's got to be big enough to fit all levels. So we did the math. I had a headache. And it turned out to be 27 cents a page. So what do we think, 30 cents a page? Well, the way I look at it is government should never round up. Think back to DEQ, 1,600 FOIA requests a year, just in that Richmond region. We're not talking all DEQ. 1,600 FOIA requests. Let's just say there's 1,600 pages apiece, and they're making 3 cents per page. No. So I said, you're in violation. It's not your actual cost. And he said, yeah, but, you know, we're trying to eliminate pennies and stuff like that. And I'm like, I get you. Go to 25 cents. Then it's not a penny situation, and you are below, and you're bulletproof. But those are some of the things of how do you parse this out. And so it really is about how you approach this law, instead of like, you know, we as citizens appreciate its importance. And we in government appreciate its importance when it impacts us as a citizen. But we need the big picture of why the heck we're doing it. And as I try to convey to government, you know, I know it was Easter and Passover. Everybody who watched Ben-Hur, you know, how many times have you seen it? You swear you're not going to watch it, and next thing you're watching all of Ben-Hur. But, you know, Ben-Hur was a slave, and on the ships, all those movies, and you see all the thousands of oars coming out. That's what government is. That's the ship of state. We're just rowing. We're just rowing. And that's a good thing, because it doesn't matter who the titular head is, whether it's the mayor or the governor or the president, because the state of government, the ship of government keeps moving. That's what we do. And so that's the big picture of what public people are doing. Just moving that, keeping the experiment alive. And so in certain ways, I think it's positively patriotic to be a public servant. Right? Because it's not for the faint of heart. Truly. Truly. Yes, sir.
Does the FOIA invoice need to be itemized, detailed as to how they came to the sum total?
You can, the law doesn't say anything about it. It just says if you ask for an estimate, they have to provide one. That's the law.
How do you figure labor?
Labor is the hourly rate.
Hourly rate of the person doing the job.
Right. And that's where reasonableness comes in, because we had an instance where the state veterinarian decided, I'm going to go to the basement and I'm going to search. You know, the fact of nature is the higher mucky you are, what's the likelihood you're going in the basement to search? Yeah, no. That's why God made me. But the state vet said, no, I'm going. He charged out this FOIA request at his $145,000 a year job. Actual cost, sure. That's where that reasonable word comes in. Is it reasonable to pass that on? You were just acting administratively. This is not rocket science. So you got to think about that. We at the FOIA Council, we're just lawyers. We do the search. So we do the search. You think I charge people? Well, plus with the FOIA Council, it's kind of on us to do it right, you know? And believe me, I've messed it up a little bit from time to time. I don't charge my hourly rate. I charge administrative rate, because that's really it is. And what I ask the government is to think about it this way. Who in government and state and local government has a top secret security clearance? And virtually nobody does. And I say, well, who puts their stuff in a burn bag? And they're, what? What's a burn bag? I work for the State Department. We didn't recycle. Things went into a big paper bag that said burn down the side, and at the end of the day, you stapled it, and the elves came, and they were incinerated. My point in raising that to government is, we so often is, they're ours. Like the citizens are the enemy. Hey man, this is not type secret security clearance kind of work. We don't got national security kind of issues going on. Semi-permeable membrane. Things come in, things come out. That's how it goes. And to drive it home further, it's an administrative act. And those of you that are in the government, when you retire or you change your job, what are you taking with you? You're going to be loading files? Yeah, I don't think so. So again, perspective. Just don't tell me we're so busy in government and then violate the 5-day rule. If you're so busy, then go 5 days or less, and this is done. That's the attitude. Get it done to for your fellow citizens. I got nothing else and it's like, but I'm happy to answer any questions. If anybody wants to leave, that's fine. I'll stick around, and so I don't want to, like, Mike would get all, we're on schedule here. We'll take him out.
Listen, I don't know about you, but that was pretty fabulous. And fun, and prompt, and wonderful, really. Thank you for coming.
You're welcome, my pleasure.
And thank all of you for coming, too.
Yes,
Really,
absolutely.
really
Thank you, guys.
Thank you.
Thank you.
All right.